Restating the record. Oh, Your Honor, in that case, the judicial practice under Michigan Rule 8.0 under WP.
Before we even hear a single ruling, this case is already loaded with tension. What you're about to watch isn't a dramatic trial with witnesses on the stand. It's something far more dangerous for the defendant. A plea hearing involving repeated violations of a protection order. And that detail matters more than most people realize. Protection orders aren't suggestions, they're court commands. Break them once, the court might warn you. Break them again, and suddenly every word you say is under a microscope. The defendant here is facing two separate stalking-related misdemeanor cases, each carrying up to 1 year in jail, fines, probation, and long-term consequences that go far beyond today's courtroom. What makes this especially volatile is that these violations happened after the defendant was already told to stop contacting the protected individual. That's the kind of fact judges take personally, because at that point, it's not just about behavior, it's about respect for the authority of the court. Judge Simpson moves fast, stays controlled, and gives very little away emotionally, but don't mistake that calm for leniency. Throughout this hearing, you'll see the judge repeatedly circle back to one core question. Can the court trust this defendant to follow orders? Everything that follows, every explanation, every excuse, every emotional appeal, will be measured against that single issue. So as you watch this unfold, ask yourself, if someone breaks a court order twice, does remorse after the fact actually matter? Or is the damage already done?
Yeah, you were getting way ahead of yourself, huh? You just walked up like you. Not like she could play in the sandbox. She like owned it or something. Permission to practice is granted. So
Morales.
that was it. All right, what are we doing? You have. I see the forms. All right, in the case ending in 350, I have a plea form that indicates that the defendant will be pleading guilty to an added count 2 of stalking, the 1 year offense. Upon a successful plea to that charge, count 1 would be dismissed. In the other matter ending in 341, I have that same agreement. The 1 year offense of stalking, he'll plead guilty to that, and count 1 would be dismissed. That is the court's full understanding of the. Has he signed it, Vice Right? Really? Oh, it's in 1. Okay. Oh, she's on top of it today. What? Okay. I have him sworn.
Raise your right hand. You solemnly swear to affirm the testimony about your Yes, sir. Morales.
All right, sir, it is this court's understanding that you are going to be pleading guilty to 2 charges of stalking. Is that correct?
Yes, Your Honor.
Okay, both of those are misdemeanors punishable by up to 1 year incarceration, $1,000 fine plus court costs.
This is one of the most important moments in the entire hearing, even though it sounds routine. Judge Simpson is doing something very deliberate here. He's making sure the defendant fully understands the maximum exposure. 2 separate misdemeanor stalking charges means this isn't a slap on the wrist scenario. We're talking potential jail time, probation stretching years into the future, and a criminal record that follows him long after this case ends. Notice how carefully the judge explains that he will not be the sentencing judge. That's critical. This plea locks the defendant in, but the actual punishment will be decided later by Judge Barr. In other words, today isn't about mercy, it's about accountability. Once the plea is entered, there's no trial, no jury, no opportunity to argue innocence later. Also pay attention to how the defendant answers. Short responses, no hesitation, no confusion. That matters because later, the defense will argue misunderstanding, but right here, on the record, the defendant confirms he understands exactly what he's giving up. Trial rights, appeal rights, and the chance to challenge the charges.
Or up to 5 years probation. You understand that?
Yes, Your Honor.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in both of these matters in the 1482 District Court.
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty
Yes, Your Honor. I do.
to the charge of stalking as contained in case ending in 350. How do you plead?
Guilty.
to that same charge as contained in the case ending in 341. How do you plead?
Guilty as well.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of rights.
Yes, Your Honor.
Are you on probation or parole?
Not current.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes.
and because you believe that you're guilty of these offenses?
Yes, Your Honor.
All right, starting in the case ending in 350. See if I can find my paperwork. Case ending in 350 on the date it's between March 11th, 2025 and March 16th, 2025. What did you do with reference to a Karis Poli that makes you think that you're guilty of this offense?
I violated my PPO.
All right, you had a PPO in place that you were to stay away from that person and not contact them?
Yes, Your Honor.
And you did contact them between those dates
Yes, Your Honor.
on one occasion or repeated occasions?
Repeated occasion.
All right.
That single phrase, repeated occasion, is devastating. From a legal standpoint, it strips away almost every defense argument that could soften this case. Courts treat one violation differently than a pattern. A repeated violation signals choice, not accident. And Judge Simpson immediately drills down on that distinction by confirming dates, frequency, and intent. Here's where protection orders often trip people up. Consent doesn't matter. Even if the protected person reaches out first, the responsibility remains on the defendant to not respond. That's not emotional logic, that's legal reality. And when the defendant admits repeated contact after knowing a PO existed, the court's concern shifts from misunderstanding to defiance. This also explains why judges take stalking cases seriously even when there's no physical violence involved. The law recognizes patterns of contact as escalation risks. Judges are trained to interrupt those patterns early, sometimes harshly, because waiting too long can lead to far worse outcomes.
In the case ending in 341, on the date of March 22nd, 2025, what you do is a reference to a Karis Poli.
Same thing, repeated offense.
Okay, but that was on that same date. You violated the PPO
Yes, Your Honor.
of repeated contact to that individual?
Yes, Your Honor.
All right. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
People are satisfied, Your Honor.
Court will accept the defendant's pleas to count 2 in each case. Count 1 is dismissed. Pre-sentence investigation and report is ordered in both cases. Sentencing will occur
April 17th at 11 a.m. before Judge Bar.
April 17th, 2025, 11 a.m. before Judge Bar. Bond will
Your
continue.
Honor, may I just,
I knew it. Go ahead.
Your Honor, Mr. Morales is a 23-year-old devoted father of 3. He is the sole provider for both his mother and 3 children. He is actively working to better his life and enroll in school this summer to enhance his education and future job prospects. He acknowledges in his violation of the PO, and I believe it was just a misunderstanding between him and the complaining witness. There was no malicious intent in any way. If you were to look at those,
Pardon? There was no.
malicious intent for him to, like when he was sending those messages to the complaining witness, you would see that they were not out of goodwill. He didn't know that it was a violation, Your Honor, to him.
This is the emotional pivot of the hearing. The defense shifts strategy from legal argument to human appeal. Fatherhood, financial responsibility, education plans, remorse. And make no mistake, judges do care about those things, but they care about something else more. Credibility. The problem here is timing. The defense argues misunderstanding, but the record already shows the defendant acknowledged the protection order and continued contact afterward. Judge Simpson zeroes in on that inconsistency almost immediately. He doesn't raise his voice. He doesn't argue. He simply asks logical follow-up questions that expose the gap between explanation and behavior. Another key issue is the "she contacted him first" argument. That's one of the most common misconceptions in PO cases, and courts reject it consistently. The burden is never shared. The court order applies to one person, and that person must comply regardless of emotional complexity.
Stretches her if she reached out first. It was almost communication. It wasn't done to purposely violate his PPO. Mr. Morales now understands.
Did he have
that
knowledge of the PPO?
He did. But
Yeah,
he-
oh, okay.
I think he just misunderstood that even if she consents to it, it still would be a violation, but now he's fully aware of that because he does not plan on ever speaking to her again. He just wants to take care of his two children and be a better father and a son to his mother. He has a home to stay with his mother, and his waiting witness lives somewhere else.
So when the first set of incidents occurred, he thought that was consensual? That was a question.
Yes.
And so then when the second one occurred, he thought that that same thing was still okay after being contacted about the first one?
No, Your Honor, that's, this, if I may, if just.
Well, you got an attorney, so I don't know if you really want to talk, but go
Do
ahead.
you want me to remain silent?
No, Your Honor,
Yeah.
I believe Mr. Morales, the first time it was, I'm understanding, is reached out first. I don't believe that there was any contact on his end. And the second time there was, after the complaining witness did try to reach out, and he did reach out.
Response from the people.
Your Honor, we'll leave it at the discretion of the court, but if he were to be released, we'd ask him to be placed on GPS custody, Your Honor.
And you understand, the PPO is still in place.
Yes, Your Honor.
And Mr. Morales expresses no intent to even think about this, Your Honor. Let alone try to reach out to her. He just-
Well, that's what I'm trying to figure out. After the first case comes up, didn't he have that same feeling?
They were both around, I don't think, like a week apart.
Yeah, but wasn't he contacted in between that week by somebody saying you shouldn't do this?
And I think
Well, was he?
he was.
And then what happened with the second one? That's what my question.
Then they proceeded to reach out to me.
And he didn't,
I didn't know that was,
So somebody told you, you had a PPO that told you shouldn't contact this person. You were in contact with this person. When you were in contact with this person the first time, somebody told you shouldn't be in contact with this person. And then they contacted you and you continued to contact them back because what?
I acknowledge that wholeheartedly, Your Honor. That was my mistake because it wasn't on them for me to be held responsible for what was in place for me. I do acknowledge that wholeheartedly that, may have crossed that line. And I don't plan on doing that again. I just want to put.
How do you, okay, but you violated the PPO, which is a court order,
Yes, sir.
right? You were told after the first set of incidents not to contact this person. And then there was subsequent contact. So if I let you out now with that same admonition, how do I know that you're going to even follow the court's order?
This is the heart of Judge Simpson's concern, and it's where the tone of the hearing hardens. The judge isn't debating guilt anymore. That's settled. He's assessing risk, specifically risk to the protected individual and risk to the integrity of the court's authority. The judge walks the timeline carefully. First violation, warning given. Second violation occurs anyway. That sequence matters more than anything else. From the bench, it looks like a pattern of disregard, even if the defendant insists otherwise. Judges don't operate on hope. They operate on demonstrated behavior. Notice how the judge interrupts explanations with blunt clarity. This isn't hostility, it's judicial reality. Courts are flooded with defendants who promise change after consequences appear. What separates those who get leniency from those who don't is whether their actions before consequences show restraint.
I understand where this is going, Your Honor. I do.
No, you don't, but go ahead.
I don't, not all the way. Because my first time in, you know what I mean? I do wholeheartedly acknowledge that, though, that I wasn't making the right decision. And,
and Your Honor, I have spoken with Mr. Morales in jail a few times over this past week, reminding him that if anything were to happen, he does not ever contact her. And he has expressed true remorse for his actions and they were a mistake. And I do believe Mr. Morales now understands his PPO and what that means. And
He didn't understand it before?
he did.
I'm just trying to gain a full understanding of what's going on in his head. Because you're gonna tell me this, somebody told him once, then told him again, and we have the same behavior, and I'm trying to figure out if I let him out, how do I have any?
Mr. Morales had time to sit in jail the past few weeks and really reflect on the fact that his kids are more important than trying to be in contact with his witness and being a son to his mom and a father to his two children who are 3 months and 2 years old.
There's an original order, which is an exclusion zone for the tether. But I don't know if that exclusion zone still applies. Yes. Okay. We've had a, quite frankly, rather extensive bench conference. My understanding is that the defendant has a DV before Judge Barr, which he's set to appear on today. That in that DV, his bond is denied. But the reason his bond is denied on that case is because of the aggravated stalking, which was the one charge in this case. Did I have that right? Right. Okay. So here's what I'm going to do and what I indicated to counsel I'll do. I will hold the files. I will at this time, I will deny your request for any change in bond.
This ruling is measured, conditional, and very telling. Judge Simpson doesn't slam the door permanently, but he doesn't open it either. He ties the defendant's freedom to what happens in another courtroom before Judge Barr, specifically a domestic violence case connected to the same conduct. That's not procedural coincidence, it's judicial coordination. Courts communicate through rulings, and Judge Simpson is signaling that the broader pattern of behavior matters more than isolated charges. By holding the file and denying bond for now, the judge prioritizes consistency and public safety without overstepping another judge's authority. This is also a reminder that bond decisions are not punishment. They're risk assessments. The court isn't saying the defendant deserves jail today. It's saying the court isn't convinced release is safe yet. For the defense, this is a partial loss. For the prosecution, it's a protective win. And for the defendant, it's a stark reminder that trust, once fractured, takes more than words to rebuild. Audience question: should bond decisions lean more toward caution when court orders are violated repeatedly, even if the charges are misdemeanors?
If after that hearing before Judge Barr, since he won't be before Judge Barr in these cases till the 17th, if Judge Barr releases him on the other case, then I will reconsider my decision on this case and may release him. Okay?
Thank you, Your Honor.
Thank you.
Thank you.
So at this time, his bond is continued. What time is his hearing before Judge Barr?
It's at 11 a.m. Your Honor.
13 minutes.
Can we call it peace? Why? Court calls the case People versus Brandon Carter.
This case ultimately comes down to one principle. Court orders only work if they're enforced. The defendant admitted to 2 counts of stalking tied directly to violations of a protection order. The pleas were entered knowingly, voluntarily, and on the record. Judge Simpson ensured procedural fairness, protected the integrity of the court, and made clear that repeated violations cannot be brushed aside as confusion. The ruling didn't end the case, it paused it. Sentencing now rests with Judge Barr, and the defendant's future hinges on whether the court believes compliance will finally replace excuses. The broader implication here is clear. Protection orders are not negotiable, and courts will prioritize safety over sympathy when patterns emerge. Cases like this remind us that accountability isn't about emotion, it's about consistency. The law draws lines for a reason, and crossing them repeatedly carries consequences. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.